was the case that exposed gangland Britain and seared an indelible image of the criminal's underworld code of retribution on the national psyche. A blue Range Rover had been discovered in a secluded farm tract deep in the Essex countryside. Inside sat the three blood-soaked bodies of major local drug dealers. The men had been executed, shot in the face with a pump-action shotgun. The triple murder may have taken less than 3 seconds, but overnight it would become one of the most notorious killings in Britain for decades. A massive police investigation would eventually lead to the conviction of 2 men in the case known simply throughout the world as the Essex Range Rover murders. And for many years, that was that. Justice, it seemed, had been served. However, vital new evidence has now emerged that could set free those who were in prison for life over the killings on a remote farm tract close to the village of Rettendon 10 years ago. Behind the swooping Gothic facade of the Court of Appeal, new developments will be heard this month that raise fresh doubts over the safeties of the convictions. The appeal raises the prospect that there was a miscarriage of justice, carrying implications as grave as those raised by the release of the Guildford 4 and Birmingham 6. But it also raises another burning question that has dogged the case since the 3 bodies were discovered that frosty morning on the 7th of December 1995. Who really was responsible? Already the appeal case reads like a classic thriller, scented as if it's upon a financial deal between one of Britain's most successful crime writers and its most famous Supergrass, while once again lifting a veil on a vengeful, violent criminal underworld. Jack Worms and Michael Steele were jailed for life over the triple killings in 1998, following a £1.5 million murder trial at the Old Bailey lasting almost 5 months. Throughout, both had proclaimed their innocence. Supporters are convinced the killers remain at large. Worms and Steele were sentenced almost solely on the testimony of a former friend, Darren Nichols, a convicted counterfeiter who turned police informant. So critical, in fact, was Nichols' testimonies that, summing up at the trial at the Old Bailey, the judge told the jury, "I hardly need stress the importance of Nichols' evidence. So much hinges on what he said." Yet what Mr. Justice Eden did not know at the time, and neither did the jury or the defence, was that some months before the 1997 trial, Nichols had agreed to a commercial arrangement with the journalist Tony Thompson, who later would become a best-selling true crime writer. It is understood they had agreed on a contract to collaborate on a book, which when published covered in detail numerous elements of the Range Rover murders and ultimately made Nichols several £1,000s. It is this deal that has emerged as a centre element in the forthcoming appeal case. For those seeking to quash the convictions of Steele and Worms, this discovery of the agreement represents a critical breakthrough. Could this agreement, lawyers will ask, have compromised Nichols' critical evidence? Could Nichols have embellished his testimony to create a more exciting account? If the jury had known of such a deal, would they have ventured a unanimous guilty verdict against Steele and Worms? In fact, would the costly, high-profile trial have been allowed to take place at all? A lawyer for the defence said, "The gist of the appeal is that long before giving evidence and long before committal proceedings, a Supergrass called Nichols entered into a commercial agreement with Tony Thompson that was unknown to the defence. What element does this commercial agreement between Thompson and Nichols have on the evidence of Nichols?" The decision to re-examine the issue follows an 18-month investigation by the CCRC, an independent body set up to investigate suspected miscarriages of justice. During its inquiry, the CCRC opted for the rare move of instructing Herefordshire Police to investigate its concerns, a move that allows a witness to be placed under caution and key evidence to be seized. The resulting 70-page report and their findings convinced both the Crown Prosecution Service and the Court of Appeal that the case was robust enough to be heard. Those close to the case believe it could go either way, with CCRC sources confirming that it is Thompson's pre-trial arrangement with the Supergrass that is a key element, yet potentially more damaging allegations surrounding the case could emerge in court. Lawyers acting for the convicted men will question whether Essex Police knew of the deal between Thompson and Nichols, and if so, why the defence was not told. We simply say that the circumstances are such that the police would inevitably have known about the arrangement with Thompson, if not in detail then certainly in broad terms, said one. At the time the deal with Thompson was brokered, Nichols was under the police's witness protection programme. Advocates for Thompson, however, insist that the police had no knowledge of his arrangement with Nichols. Among the intrigue, one certainly remains. Britain's fascination with the Essex firm, a criminal gang whose violent reign ended with the discovery inside the Range Rover, is sure to be rekindled. So intense was the interest surrounding the original trial that soon after a major film called Essex Boys was commissioned. Uncompromising and brutal, the film stars Sean Bean as a former convict skulking around the marshland and industrial estates of South Essex. Upon release in the year 2000, distributors knew the biggest selling point was not fancy special effects or Hollywood actors. Instead, it was the iconic image of a metallic blue Range Rover in Workhouse Lane. So they gave the public what they wanted. Essex Boys was promoted simply with the promise that it was inspired by the Rettendon Range Rover murders. Travel north of the winding spine of the A130 from the dark flat wildness of the East Tilbury marshes to central Essex, and it isn't likely you will notice the muddy track on the left near Rettendon. It is 10 years since the Essex firm, Pat Tate, Tony Tucker and Craig Rolfe were found dead, but Workhouse Lane remains a grim landmark in a region synonymous with flash gangsters, fast money and occasional fury. Each of the men found in the Range Rover that clear winter morning can be viewed as a product of the Essex Badlands, dysfunctional career criminals not shy of following through their menacing threats. Slumped behind the wheel was 26-year-old cocaine addict Rolfe, who not long before meeting his end was suspected of murdering a rival drug dealer. Behind sat the hulking 18-stone frame of Tate, short on temper but with a long history of violence. Just the night before his death, the 36-year-old had grabbed the head of a Basildon pizza shop manager and slammed it into a glass-glazed counter following a row over pizza toppings. Typically, the victim declined to press charges. Perhaps he knew of Tate's past and his close friendship with men like Kenneth Knoll, convicted in the M25 road rage murder of Stephen Cameron and accused of smelting the gold from the Brinksmat robbery. Alongside Rolfe, in the front passenger seat sat Tucker. No longer would he be speeding along the A130 in the black Porsche registered TT9 as a prominent security guard who controlled the Essex trade in the local nightclubs. Tucker too counted the famous amongst his friends, acting as a bodyguard to one of Britain's best-known former boxers, Nigel Benn. The 38-year-old was also linked to another household name, although the two had never met. Weeks before he was found with his face hanging off, Tucker had supplied the ecstasy tablet that killed Leah Betts on her 18th birthday. That the trio were associated with one of Britain's most disturbing ecstasy deaths was not surprising to those who studied the region's criminal fraternity. South Essex, in the mid-90s, was the distribution corridor of ecstasy from Holland. Men like Tucker and Tate were thought to be earning £1 million a year from feeding the nearby capital with its favourite party drug. Ultimately, though, it was claimed that the law of more riches from drugs sealed their demise. According to Nichols' testimony, which was denied by both Steele and Womes, Tate, Tucker and Rolfe had become embroiled in a festering feud with the two convicted men over a shipment of poor quality cannabis. Steele had promised to make it up, the Old Bailey heard, by offering the trio a deal on a cocaine cargo which would be flown into Essex for a makeshift landing strip beside the village of Rettendon. On the night of the 6th of December 1995, Nichols claimed that Steele and Womes shot the three men in their Range Rover. Moments later, Nichols, unaware of what had taken place, arrived to pick his two friends up. Steele, the jury was told, had double-crossed the Essex firm before they, in turn, could kill him. In the book that Thompson wrote in collaboration with Nichols, little is left to the imagination when it comes to the night of the murders. They're all covered in blood and bits of brain. They start laughing and joking, giggling like a couple of schoolboys who've just seen their first naked women, writes Nichols, as he describes the frenzied moments following the shootings and the instant he first realises his friends have implicated him in the extinction of the Essex firm. The passage is amongst the first in the book, part of an opening chapter called "If You Want to Know the Truth." It is precisely that which some feel is at stake in the Court of Appeal on the 18th of January, a final chance perhaps for those who have attempted to undermine the credibility of Nichols' testimony in a quest to prove that Steele and Wholmes are not guilty of the murders. Allegations put forward over the years have included suggestions that the real Rettendon killers in fact belonged to a criminal cartel in East London. The court will hear evidence from mobile phone experts that place Wholmes some distance from the murder scene that night. Yet it is the pre-trial deal between Thompson that is likely to determine whether Steele and Wholmes are freed after serving just 7 years of their triple life sentences. The book at the centre of the deal, Thompson's second, is called Blogs 19. Before prosecuted, witnesses are given new identities that are known as blogs, Nichols being number 19. Investigators from the CCRC are understood to have analysed the testimonies that Nichols supplied before and after the deal with Thompson was made. Despite examination, it is understood the accounts of Nichols did not change. Supporters of Thompson also claim that when the original agreement was reached, it was not strictly for a book on the Range Rover triple murder. Instead, when Nichols approached Thompson in 1997, whilst the journalist was working at Time Out in London, the deal was to offer a rare glimpse into the life of the police witness protection programme rather than a commentary on the Range Rover murders. Another critical point is that Nichols did make money from the pre-trial book deal, although not much, in fact, little more than £5,000 over a 3-year period. Blogs 19 was published in early 2000, 2 years after Steele and Wholmes were sentenced and shortly after Thompson joined the Observer as its crime correspondent before leaving last year to further his writing career. Whatever else, the case will raise fresh questions over the ethics of payments to witnesses and the dangers of checkbook journalism. By strange coincidence, in the month after Steele and Wholmes were jailed for life in January 1998, the government called for new controls outlawing the buying up of witnesses. It followed concern after the reports of the murder trial of Rosemary West, in which up to 19 witnesses were said to have entered into agreements with the media. The media law expert Mark Stevens is amongst those who believe only a blanket ban prohibiting witnesses selling their stories or agreeing to a contract before a trial will stop the practice. Lawyers who can prove knowledge of any form of payment or commercial agreement with witnesses can easily portray them as inducements to embroider their tales or lie to increase the rewards on offer. The case may be damaging for the media, but the fallout from the hearing promises to reverberate wildly. Lawyers for the convicted men promise that the allegations will be breathless, promising to reveal who knew what, when, why, and who was covering that up. Lee Craddock acted as Darren Nichols' solicitor in the early part of his detention, when Darren was interviewed under caution regarding his involvement in the murders of Pat Tate, Tony Tucker and Craig Rolfe, and the offences for which he'd been arrested. Because of the importance of his evidence, his statement is read almost in its entirety. He states, "Between September 1995 and December 1997, I was employed as an assistant solicitor by Maudsley, Wright and Pearson. During my employment, I think in around about May 96, my firm acquired a client by the name of Darren Nichols. I first learned of this new client when I received a telephone call at home from Mark Pearson, who is the partner in charge of the criminal department. Mark informed me that he'd been in contact with Darren Nichols. I cannot recall whether Mark had attended the police station and met with Darren Nichols, or whether he'd spoken to him over the telephone. From memory, I believe that Mark informed me that Darren had been arrested in possession of a large quantity of cannabis resin and had been subsequently arrested whilst in custody in connection with a triple murder which had occurred, I think, earlier that year or late the previous year at Rettendon, Essex. Mark Pearson was a very experienced criminal practitioner who had previous experience advising clients on the operation of the witness protection scheme. As such, I relied on his experience and advice to formulate my approach to dealing with Darren Nichols whilst he was in custody. As I recall, there was a number of other people in custody throughout that part of Essex for linked matters, which meant there was a shortage of local solicitors who were able, because of conflicts of interest, to represent Darren. I believe that either the police or Darren Nichols had contacted the chairman of the Mid-Essex Law Society, who then recommended my firm. Darren had already been interviewed by the police in the presence of the solicitor's representative called Mr. Odie. I cannot remember exactly why Darren decided that he no longer wished to be represented by Mr. Odie, but believe it may be because Darren felt that Odie was out of his depth. In my opinion, it would have been unlikely that the police would have encouraged Darren to use my firm. At the time, I would describe the relationship between my firm and the police, and in particular HQCID, as uneasy. I attended Rayleigh Police Station, where initially I met the police officers leading the investigation. I think that I met in the first instance Detective Superintendents Bright and Story. I asked both of these officers a number of questions in relation to the evidence that had been obtained in relation to Darren Nichols. As far as I can recall, they provided me with satisfactory answers to all of my questions. I then met Darren Nichols, who during the consultation told me his version of events leading to being in custody for drugs offences and a triple murder. I have been asked about specific parts of the account that Darren gave to me, and it is accurate to say that his account to me was in substance the same, although briefer than the one he gave to the police during subsequent taped recorded interviews. I have been asked by DC Powell about a number of specific points. Firstly, did Darren Nichols ever tell me that he knew the murders were going to happen before they actually occurred? I distinctly remember Darren Nichols saying that he had no idea that the murders were going to take place beforehand. Secondly, I have been asked whether Darren Nichols ever informed me that he told ex-DC Wolfgang Bird about the murders after they had been committed, but before Darren had been arrested. Darren had been an informant for this officer. Again, I can recall discussing Darren Nichols' contact with Bird in some detail. As far as I can recall, Darren has never discussed the murders with Bird. I have been asked about Francis Reed and whether he had a knowledgeable role in Darren Nichols' involvement in drug offences. From memory, I think, but cannot be certain, Darren told me that Reed was unaware of his activities in his decision, but eventually decided that he would assist the police. A major factor in his decision was that Darren was extremely worried for his safety of his wife and child, and felt that he should do all he could do to ensure their safety. From then onwards, I'm able to state that I believe I was present at all the taped interviews that Darren Nichols subsequently had with the police. I'm able to state that at no time during any interview did Darren Nichols give answers from a prepared script. During the course of these interviews between Darren and the police, Darren gave his replies to the questions being asked without prompting. However, Darren would sometimes pause to consider the question before making his reply. Darren was not, in my presence, supplied with information either verbally or in writing by the police. Each interview between Darren and the police was conducted in accordance with the Police and Criminal Evidence Act and the Codes of Practice. I was not aware of any breaches, and the officers conducting the interviews conducted them in a correct manner. Had I ever suspected that Darren and the police had concocted his account or any part of his account together, then I would not have continued to represent him. Obviously, I could not be with Darren all the time whilst he was in custody, but while I was there, I did all I could to ensure that I was present when Darren was with his interviewers. An example of this was that during the breaks from interviews, I would occasionally need to make calls on my mobile telephone to my office or home, and I'd position myself just outside the interview room with the door open, so I was within earshot of any conversation between Darren and the police officers. The interviewing officers were DC Winston and DC Brown. From what I can remember, Darren gave his account of events without the need for too many questions from the pair. I do remember that Darren was asked various questions about what mobile telephone he was using at the time of the offences, and to whether he was carrying it or whether it was turned off or on. Darren asked me why he was being asked such in-depth questions about his mobile telephone, and I think I advised him that the police would be seeking to obtain it and check his calls against an itemised bidding list. Having said that, the questions appeared to be very detailed for this purpose, and it was only some time later that I became aware that the police were to use cell site analysis to plot the movements of mobile telephones. At that time, I did not know such analysis was possible, and I'm certain from Darren Nichols' reactions and questions to me, neither did he. Subsequently, Darren was charged with the drug offences and used, as I anticipated, a protected witness in the murder case. I was invited by the police to be present whilst witness statements were taken from Darren, but after consultation with junior counsel Elizabeth Marsh, declined, as this would have been an unusual action to take, which could possibly prejudice our position should Darren decide at a later date to contest the charges in relation to the drugs found in his possession. At the trial, I never saw Darren give evidence, as I was to be called to give evidence myself later in the trial. My firm continued to represent Darren, who was later sentenced for the drug offences. In all the time I had contact with Darren, it is fair to say he was someone who liked to chat. At some stage, Darren mentioned to me he was going to either make a film or write a book about his experiences, and as a result, hopefully become rich. I didn't take Darren too seriously. I took this to be a throwaway comment. I had no idea that Darren was in the process of meeting an author or a journalist and signing contracts for a book and television programme prior to the trial. At this time, I believe I'd read articles by journalist and crime writer Tony Thompson. Accordingly, had I seen or heard his name on any paperwork, i.e. a custody record, then there is a possibility that I would have realised that Darren had been in contact with a journalist. I have never met Tony Thompson, and I've been told he is a black man. I was present with Darren on occasions in the police cells when he had or was to receive visits. I have no recollection of any black people visiting Darren. Had I been aware of Darren's contact with the media prior to the trial, I would have strongly advised him that he should cut all contact with them, as it would obviously have caused him serious difficulties when it came to give his evidence. I did subsequently become aware of the book about Darren, which I read in part. I don't think from memory there was anything in the book that I recall as being inconsistent with what I knew of Darren's version of events. Elizabeth Marsh assisted in Darren Nichols' legal representation in relation to the drug offences from which he'd been arrested. She states, Darren Nichols had initially been arrested in connection with the murders and other drug importation offences. Therefore, no further action was taken against Darren Nichols in relation to the murders, and he was used as a witness in that case. Darren was, however, charged with drug offences. I first visited Darren in a police station in the early days after his initial arrest. Over the course of the next few months, I had various discussions and meetings with Darren. Darren gave evidence in the case of the murders before some time later he was sentenced for the drug offences. During the course of the conversations and meetings I had with Darren, he did mention at some stage that he was in the future intending to write a book about his experiences in relation to the offences I've described. This did not surprise me at all, as his experiences were an extraordinary sequence of events which I felt were worthy of being put into a book or even a film. Darren did not mention at this stage that he'd made any contact with any author, journalist or member of the media. I did not seek to stop Darren from writing his story, but I certainly did not encourage him to make contact with any such member of the media. I am sure it was after Darren was sentenced for the drug offences that he contacted me to ask my advice in relation to seeking an injunction against a television company to prevent the screening of a television programme about himself. I believe this was the first time I became aware that Darren had in fact made contact with the media. Up until then, I had no idea that Darren had entered into any formal contract to sell his experiences. I have today been informed by D.I. Phantom and D.C. Powell that allegations have been made that Darren Nichols lied in his evidence and concocted lies with the police who dealt with him at the time. I can say through all my dealings with Darren Nichols, his case, the solicitors and officers involved, nothing happened which gave me any indication that any such concoction had taken place or any such lies had been told. Police helped a witness in the notorious Essex boys gangland murder trial sell his story, the Court of Appeal has heard. Detectives have been accused of assisting the witness in negotiating a book, TV documentary and film deal even before the case came to court. In court, counsel Baroness Kennedy QC said the jury may have returned a different verdict had they known of the police subterfuge. She said, "We say that the police, unable to supply finance to the witnesses themselves, facilitated his link with the media. In contemporary parlance, it was outsourcing or a private finance initiative." She added that the police involvement in media negotiations throws a very different light on police conduct in the trial and their alleged collusion in framing these two men. Defence solicitors argue that fresh evidence shows Darren Nichols, a critical witness at the 1998 trial, had arranged to be paid for his story, but legal experts for the Crown strenuously deny claims of a police cover-up regarding his reliability. A police officer responsible for keeping a Supergrass witness in protective custody has denied he assisted him in striking a deal to sell his story. Detective Constable Christopher Winston was challenged by defence lawyers in the Court of Appeal to explain how the protected witness, Darren Nichols, was able to make his way from police custody in Colchester to a meeting with a journalist and a literary agent at a club near Covent Garden. The officer said he had no idea how Nichols was able to make the contact on April the 1st, 1996. He denied a suggestion he knew perfectly well that an arrangement had been put in place for Nichols to receive money from a deal with a journalist. He said he'd never met or spoken to the journalist Tony Thompson. Detective Constable Winston told 3 appeal judges the log kept of police officers' contacts with Nichols had no entries for August the 1st, 1996. He denied that Nichols, who was facing criminal charges but had turned Queen's evidence to give evidence for the prosecution, had been free to wander during his period of protective custody. Baroness Kennedy QC for Steele said Nichols had objected whether another police protection team replaced DC Winston and his colleague. She suggested the reason was that DC Winston ran a bit more tolerant regime. The officer replied, "I believe it was the opposite. We ran a tighter regime and he wanted this for his own safety." Baroness Kennedy QC went on to say, "It is clear now Supergrass Darren Nichols, the prosecution star witness, received money before the trial as a down payment on a book." Henry Blaxland QC, representing Worms, suggested certain Essex police officers knowingly colluded to ensure journalists Tony Thompson and Nichols were able to meet even when the Supergrass was meant to be in police custody. Mr. Blaxland said Nichols' evidence was the glue which held the case together. There was a body of material to undermine these accounts. What we now have demonstrated, he is a very scheming, cunning man. The following statement is from the 22nd of August 2003 from Mike Hodgkinson. At the end of October, early November 1996, I was on the protected witness unit at HMP Blanked Out. A day or so after my arrival, I recalled Darren Nichols returned to the unit, having been out with his police handlers. I think there's about 8 of us prisoners on the unit at that time. I remember meeting Darren on the day he returned. We chatted for some time, and he quickly told me that his case was to do with the Range Rover killings in Essex. Darren also told me, before the killings, he was a police informant, and that the police officer he'd been working with in Essex had been nicked soon after he, Darren, had been arrested. I cannot remember the name of the police officer Darren was working with, but I can recall Darren saying he was nicked for drugs. Thinking back, I cannot remember exactly what Darren said about when this police officer was arrested. It may have been before Darren was. Darren also told me that he intended to write a book and make a film about his case. He said the only reason for doing this was to make lots of money. I do remember that Darren was writing his story on a computer in the unit. Jeff was quite good on computers and used to help Darren. When we was at Blanked Out, Darren seemed very wary of everybody except Jeff. With regards to visitors at Blanked Out, although visitors should have been vetted by the police, in reality, anybody who wanted to visit could do so. I never had any visitors whilst at Blanked Out. I'm not sure what visitors Darren had, but I do remember that everybody on the unit knew that Darren was going to be visited by a journalist, so they all wanted to say something. The meeting with the journalist and Darren did go ahead, and the only other prisoner who spoke to the journalist was Pat. I cannot remember much about the journalist, but he was a white man, about 5'10", tall and smartly dressed. I do not remember Darren ever being visited by any black males. I can remember that Jeff did have blackmail visitors on occasions. Whilst at Blanked Out, I never saw Darren with a mobile phone or a video camera, but I do remember at both units he was always using the phones on the unit. Darren and I became fairly close at Blanked Out, and we often discussed our cases with each other. Darren started to open up to me about his case. I remember in particular sometime around Christmas 1996, while we were in the exercise yard at Blanked Out, Darren was talking about his case. I told Darren that I'd read about his case. Darren told me he was terrified that either the police wouldn't protect him as they'd promised, or that the baddies would get to him. He did seem very frightened. I remember Darren telling me that the police had told the baddies that he was an informant. Darren said he had no choice but to go along with the police. I remember Darren telling me that it was the police who concocted the story about Darren's involvement in the Range Rover killings. Darren said that in interviews he was given a script from the police officers. I said to Darren, "What do you mean concocted?" And he told me that the police would slide a piece of paper across the table with what they wanted him to say. Darren told me that some of his answers were read from the sheet of paper given to him by the police. Darren continued to do his book on the computer at Blanked Out. I remember Darren had a visitor sometime in January, I think, and it was after this visit that Darren spoke to me in the exercise yard. He said to me, "That's my story sorted," and he explained to me that his last visitor was from the media. I asked him if the story was about the protected witness unit, but he said it wasn't. It was just about his case. The visitor was a white man, but I couldn't remember much about him. With regards to visits at Blanked Out, the procedure was much tighter, and I cannot recall any visitors that Darren had. I do not recall Darren ever receiving a black male visitor. I remember that after Darren's visit from the journalist, he spoke about learning to fly a Chinook helicopter and then buying one for about £40,000, an old used army helicopter. He wanted to do helicopter taxis. I know he'd asked a female education officer if he could do a course in learning to fly helicopters. He did also say to me that the police had taken him in a helicopter on one of his trips out. During my time at Blanked Out, I had numerous conversations with Darren about his case and other things. The discussions about matters involving his case may or may not have been true, who knows. I never knew Darren before Blanked Out and know little of his background. The following statement is from Tony Thompson from the 21st of April 2005. Further to my previous statements made to Herefordshire Police concerning Darren Nichols, I have contacted Essex Police because I want to clarify some points in these statements. The reason I want to clarify these points is that because one of my previous statements may have given the wrong impression. This was a statement regarding Francis Reed. The second reason is I've received requests from the defence solicitors. From a personal point of view, I'd rather the police record my account, which I know will eventually be disclosed to the defence solicitors in this case. The first point I'd like to clarify is regarding a television programme that LWT were going to make. The contracts for this TV programme had been signed before the trial. Darren Nichols stood to receive £30,000 for making the programme. However, the project was abandoned because it was unworkable. It was impossible to hide Darren Nichols' identity. Therefore, at the time of the trial, there was no expectation that he would make a large amount of money. As far as I was concerned, in the lead up to the trial, the only deal he was involved was with the book One Way Out. Darren had received around £3,000 in advance for the book. I think this money was paid into an account with a firm of solicitors. I believe Darren received some small amounts of money from this account when he was on bail. The second point is that after the trial, there was a second television deal between myself and LWT. The rules regarding payments to a witness with criminal convictions had changed. I would therefore receive the money and then pay Darren. This meant LWT could deny any knowledge of money being paid to a witness with criminal convictions. I wish to clarify this was a completely separate deal with a completely separate contract. His contract was not signed by Darren. The total payment was £18,000, which came in 3 stages. £6,000 initially, followed by a further £6,000 and a final £6,000, which was never received because of legal action surrounding the programme. In total, I received £2,000 and Darren received £10,000. This was all conceived after the trial. It had no connection to the trial. It could not be seen as a financial motive to give false evidence at the trial. I would also like to point out that within the contract for the book One Way Out, there is a clause relating to the making of a film of the book. This was because the initial discussion with LWT was with regard to making a feature film. LWT pulled out of the deal because Darren Nichols gave oral evidence at the committal proceedings. His evidence was therefore in the public domain, and they did not need him to make a film. Again, this proves there was no financial value to the evidence Darren gave at the trial. The only information of value was his evidence of being in the witness protection program. The focal point of the book was going to be the witness protection program because it was unique. This did not rely on the outcome of the trial. In fact, a not guilty verdict may have added more value. Darren's initial motive for the book was how he was going to be portrayed by the press. He wanted to have a chance to explain what he'd done. This was a stronger motivation than financial gain. I did explain to him that he was never going to make a vast amount of money from a book. I told him that he'd get more money from a newspaper. Darren felt the newspapers would write what they wanted, whereas a book would be researched and be around for a few years. Darren was also worried that the police would stitch him up once he'd given his evidence. He feared they would drop him from the programme and leave him unsupported. He thought if the book portrayed the police in a bad light, they would think twice about stitching him up. Darren's handlers told him a senior police officer was also writing a book. This was David Bright, who subsequently wrote a book called Catching Monsters, which touches upon the Rettendam murders. I would like to say that Darren Nichols never told me he had told lies or he was going to lie. The only area I thought Darren was not entirely being truthful was about the fact that Francis Reid did not know what was going on when they went to Amsterdam and Belgium. My suspicions were first aroused at the trial when the defence made such a big issue out of it. It seemed obvious that Darren was not being truthful because of the line of questioning. It was also obvious the reason the defendants knew he was not being truthful was because they themselves were not being truthful. They could not admit that Francis Reid knew because this would implicate themselves. After the trial, while writing that section of the book, I challenged Darren about this. He didn't say anything different to what he'd said at the trial, although he did add that even if Reid knew, that Nichols would have not said anything. Darren admitted that at some point during the journey, Reid would have been able to work out what was going on. When I wrote that passage in the book, I changed the details to make it sound less stupid. The version of events Darren gave in court did not make sense and would have interrupted the book's narrative. This was my decision alone. Darren was not consulted, nor was he aware that I'd made the changes. His role in the book was purely interviewee. He did not have no part in the actual writing or editing. During initial negotiations about the book, it was going to be a first-person account by Darren. This would have meant me writing it from his point of view. However, it soon became obvious that he did not know some of the players and had not been present at some of the key events. The first-person account was obviously not going to work, so I wrote the book. The book was going to include the Rettendam murders because it was so high profile, and they were the reason he was in the witness protection programme. I would like to say there was never any discussion about the book or television programme being dependent on guilty verdict at the trial. Darren Nichols was under no pressure from me, the agents or the publishers to lie in order to get a guilty verdict. There would have been no financial benefit in him doing so. I would like to clarify details of my first contact with Darren Nichols. I think I previously told the Herefordshire officers I first had contact with Darren in August. In fact, I now believe he telephoned me in July 1996. Since giving my statements to Herefordshire, I have subsequently learnt I had a meeting with my agent in July 96. I became aware of this meeting via my agent Caroline Dornley, who had received correspondence from the defence solicitors from Worms. The solicitors had sent Caroline a letter that had obtained from the publishers Little Brown Limited. This letter mentioned she had met with Darren the week before. As a result of Caroline receiving this letter, she telephoned me and asked me if she should speak to the solicitor. I told her there was an appeal coming, that if anything we would be witnesses for the Crown, and in the first instance should give statements to the police or Crown Prosecution Service. At the same time, I had a letter from the defence solicitors asking me to contact them. It was for these reasons that I contacted Essex Police in February 2005 and asked to speak to the officer in charge of the Rettendon murders. I was subsequently telephoned by Acting Detective Inspector White of Essex Police. I contacted Essex Police to inform them that I was available to give evidence at the appeal if required. And as I said in my previous statements, Darren made the initial telephone contact with me. I then went to Harlow Police Station where I first met Darren. I think I may have visited him at Harlow on 2 occasions. As a result of these meetings, I arranged for him to meet Caroline Dornley. The initial phone calls from Darren had been a couple of weeks before the meeting with Caroline. I cannot recall the exact date of the meeting between Darren, Caroline and myself. This meeting took place at a private club in Covent Garden called Two Bridges. The meeting took place at lunchtime. Myself, Darren and Caroline were the only people present. As I can recall, Darren was in London to meet his barrister. I met Darren outside the Two Bridges. He was not accompanied by the police officers. However, I recall he was texting them during the meeting to let them know he was okay. It was my understanding Darren was on bail but residing at the police station. He was not subject to stringent conditions. Our meeting lasted between 10 to 15 minutes. Caroline offered him lunch, but he declined. Thinking back, I think Darren might have invented an appointment with his barrister as a cover for the meeting with me and Caroline. Caroline explained her role as an agent, and then she got 10% of any deal. I wanted Caroline to meet Darren so I could give him credibility with the publishers and to prove that I was actually in contact with him. Also, Caroline had never met a criminal and I wanted her to get a feel for the character, which I hoped would come out in the book. Darren then left. Caroline and I discussed which publishers we were going to approach. As I recall, Darren first telephoned me as a result of seeing Gangland Britain, which I recall came out in paperback in July 1996. He saw it and called me. Darren also told me he had seen Gangland by James Morton and he had tried to contact him but had been unsuccessful. In my previous statements, I explained that I may have signed one of the contracts on Darren's behalf. I may have signed other documents on his behalf because it was difficult to get access to him. The following statement is from Caroline Dornley from the 13th of April 2005. I'm employed as head of books by Peters Fraser and Dunlop Writers Agents, Drury House, London. I've been asked by the police to recall my dealings with Tony Thompson and Darren Nichols, who used the pseudonym Ken Rugby. In 1996, I was employed by Peters Fraser and Dunlop as a literary agent. In this role, I find publishers for books my clients wish to write. We collect money from the publishers, deduct our commission, then forward it to a client. Our commission is 10% plus VAT. I became an agent for Tony Thompson in the early 90s. Prior to 1996, I'd already sold one of his books called Gangland Britain. I recall in July 1996, Tony Thompson telephoned me and told me he had an interesting project for a book involving another man. He suggested a meeting to discuss the project. He told me the other man's name was Ken Rugby. We did have a phone conversation about the proposed book, but I cannot now recall what was said. I wanted to meet this Ken Rugby to satisfy myself about what the book would be. I had to reassure myself about the project before I could approach a publisher. I can now recall the exact date Tony Thompson telephoned me, however I still have my 1996 diary. It shows the meeting appointment with Tony Thompson and Ken Rugby on the 26th of July 1996. Its entry is crossed out and the appointment is rescheduled to August the 1st. I can therefore say that Tony Thompson had telephoned me a few days prior to the 26th of July 1996. I like to get proposals resolved as soon as possible, so I'd have wanted the meeting to be arranged right away. On the 1st of August 96, I met with Tony Thompson and Ken Rugby at Two Bridges Place just round the corner from Charing Cross Police Station. I cannot recall any details of the meeting. I wanted to satisfy myself that Ken Rugby was willing to cooperate with Tony Thompson on the book and that he was telling the truth. At the end of the meeting, I was happy I had the grounds for a book and that it had a reasonable chance of finding a publisher. I have been asked what time the meeting took place. I cannot be sure, but it would have been around lunchtime. I would have then considered which publishers I would approach. I drew up a short list of 4 or 5 publishers. One of the publishers was Little Brown UK Limited. On the 7th of August 96, I drew up a confidential agreement in respect of a book by Tony Thompson, which was going to be titled One Way Out. A confidential agreement is not normally required for original books. It was my understanding that Ken Rugby was in hiding because he'd given information about what became known as the Essex murders. I did this to ensure they kept details of the proposed book private. I did not want them going to the newspaper with the story. On the 8th of August 96, I sent a letter to Little Brown UK Limited together with a copy of the confidential agreement. I also sent identical letters and agreements to 4 other publishers. In the event only Little Brown offered to publish the book. On the 8th of August 96, I also drew up a terms of business letter for Ken Rugby. This letter authorises Peters, Frasers and Dunlop to act as an agent for Ken Rugby. I would have given this document to Tony Thompson for Ken Rugby's signature. At some point this was returned to me, signed by Darren Nichols and dated the 17th of August 1996. At some point Tony Thompson told me Ken Rugby's real name was Darren Nichols, but I cannot recall exactly when this was. On the 16th of August 96, I sent a handwritten letter to Little Brown UK Limited. I am confirming what we have agreed prior to preparing the contract. In my file, I also have the collaboration agreement between Tony Thompson and Ken Rugby, dated the 17th of August 1996. This is signed by both Thompson and Nichols. I think this was most likely signed at the same time as the terms of business. In my file, I also have an assignment of copyright dated 17th of August 96 between Tony Thompson and Ken Rugby, again signed by both. This collaboration agreement sets out who owns the copyright to the book, how the proceeds would be divided, and how they are collaborating on the book. The assignment of copyright is an agreement to the effect that one person, i.e. Tony Thompson, will be making the decisions about the book because Ken Rugby would be unavailable for most of the time. Somewhere between the contracts being signed and the publication of the book, it changed from One Way Out to Blogs 19. I wish to add that I still manage Tony Thompson. I've had no further contact with Ken Rugby, Darren Nichols. I have received letters from defence solicitors requesting information about my dealings with Tony Thompson. I wrote and told the solicitors I would not provide them with any information. I'm aware a proposal was made for a TV programme, but it was never made. As far as I'm aware, the initial £20,000 was paid to Thompson and Nichols, which was divided as per the collaboration agreement. They also received a further £2,464 in royalties. They received a total of £5,000 for the TV programme, which was divided equally.